So now that we've covered incapacity, probate, beneficiary designations, and joint tenancy, let's move in and talk about revocable living trusts. You know, we feel that that is the best way to plan for your estate. So much in the way of benefits, flexibility, planning for the what ifs in life. You know, we all think life is going to go on in this nice straight line, but we know that in some families, that straight line turns into a 90-degree right turn or a 90-degree left turn, or maybe you hit both turns at once. You just don't know. The trust is a tremendous tool in any estate planner's basket to offer to clients to try to address those issues. How do we avoid probate? How do we keep control of the assets? How do we keep our estate and our affairs private? And that's a big one. Tim does a lot of farm and ranch planning for clients in rural locations. And you know, you think of a client that's in a small town or small community. Well, if everything's down at the courthouse and it's a public record, maybe you don't want all your assets, all of your debts and creditors, your information on who's getting what out of the estate. Maybe you don't want that public. So privacy is a big issue. Obviously, cost savings. Typically, you know, attorney's fees in trust administration and settlement and things like that are typically quite a bit less than what you would experience in a probate. The speed, the convenience, the ease, you know, of administering a trust where we don't have to go to the court. You know, the next in line trustee just simply calls us, tells us what happened, we prepare a few documents, and the trustee can really be off and running to start taking care of things. You know, one of the things that I think Tim and I both typically assume, you know, when we meet with a client, whether it's a single person or a married couple, we typically presume the reason you're wanting to do estate planning is to get a good plan in place to make the transfer of assets as easy, as efficient, the least amount of headaches for your children or heirs or surviving spouse. Keep the costs down. You know, you're doing the estate planning for others. You're making a plan to have a smooth transition at a time that can be filled with a lot of very strong emotions, a lot of grief, a lot of uncertainty, and we just feel the trust offers a tremendous advantage over those other methods we talked about. And we're going to dive into some of the things that a trust can do here.
You should consider your estate plan as a moving process. It's not once and you're done. When we have people come in and they're trying to decide how they want to provide for children, or who they want to have in control, we tell them, don't try to plan out for 20 years from now. Plan out for, say, the next 5 years. Something happens to you right now or very soon to right now. What would be what you need to have in place? We can change it over time very easily once everything's in the computer. But, you know, think about, well, based on the age of my children right now, do I want them in charge or do I not want them in charge? Well, we can change it later so that they are, if maybe there's a reason not to have that right now. And lots of other things that are similar time-wise, where you might decide that right now your parents might be a good choice for minor children, for guardians, or whatever the situation might be. But we all know that in 15 or 20 years, that's probably not going to be the case. But you need to understand that your plan is amendable and changeable, and you're going to do a lot poorer job of planning if you're trying to plan for what will happen 25 years from now than if you're just planning for right now, the next 5 years. What's the plan that I want to have in place?
Yeah, let's talk a little bit about what a trust is. A trust is a document, a legal agreement. It's similar to a will in that it contains instructions for what needs to happen at your death. It says who the beneficiaries are, who's able to receive the assets. It names who the trustee is. The trustee has a role much like an executor. They're responsible for gathering the assets, paying the bills, wrapping up affairs, and then following the terms of the document to distribute or do with the assets as you've requested. You know, in a trust, oftentimes I get a question of, well, do I need to have a bank or a financial company or an attorney be in charge of the trust? And the answer quite simply is no. When you create your trust, your day-to-day life does not change in any appreciable way. You still have complete control of your assets. You're in charge of the trust. You operate the same way. Your taxes, income taxes, stay the exact same as they always have. You know, I often tell folks the example I use to explain how their lives will stay the same. You know, when you go to the grocery store and write out a check or use your bank account to pay for your groceries for the week, you're going to use the same account, the same checkbook, sign the checks the same way, pay everything, and do everything on your day-to-day life the exact same. During your lifetime, you'll operate just like normal.
The trust is really a contract, and contract law is what controls over the interpretation of the document. It's a contract between the grantor of the trust, the person who creates the trust, sometimes called a settlor or trustor. I usually say one of those "or" words. That's who created it.
Attorneys are really good at coming up with 3 or 4 names that are different, but all refer to the same thing. And that's where Tim's saying the settlor, grantor, trustor, all those "or" words.
Okay, so we have the person who creates the trust, and the agreement is with the trustee to hold the assets and do what the trust directs the trustee to do. And when you do your own revocable living trust, inside that document there'll be language that says that you are accepting that role as trustee and agreeing to the trust arrangement. But if you become incapacitated or die, then the successor trustee that you've named needs to sign an acceptance of that fiduciary position and say, yes, I agree to be the trustee of this trust and to do what I'm supposed to do in that position. So it is a contract. And before we had a statute that allowed the living trust to function, which means that, you know, on a traditional living trust, I create my trust with my property, I'm the trustee, and I'm the lifetime beneficiary. And so I fill all 3 roles as the grantor, the trustee, and the beneficiary. And at common law, there was a doctrine of merger that said, well, you can't be all 3. If you're all 3, then the trust doesn't exist. And then we passed statutes in the various states that said, no, we're going to allow that so that we can name a successor trustee to come in and that trust arrangement will work.
Yeah, I think that's important. You know, if the person that creates the trust, if they pass away, they can pick who they want to be the successor or the backup trustees. Maybe it's an adult child, maybe it's a spouse, maybe it's a friend, a neighbor, some other relative. Maybe it is a bank or corporate institution. But you get that freedom to choose and pick whoever you want to be in charge of wrapping things up.
What people tend to really appreciate about a trust as opposed to probate is that it's private. All of those things that we have to file in the probate court are not open to the public to take a look at, to see who is getting what and what assets there are or what creditors there might be. All of that is done in private. Probably the main one, and actually I can tell you that yesterday I had a client come in, a lady that I hadn't known, and she said she was here because she had just completed a probate for her deceased husband who died last year, and she wanted to make sure that that would not happen at her death, and it was fresh in her memory. And I went through those things, and she just nodded her head because of as we talked about, the antiquated slowness of the probate process, where we have to petition the court and then wait for time to pass and then get a court order, and it moves slowly, and you can't even close an estate until more than 6 months have passed from the date of death. And it's more typical, as we've seen and looked at in files in Kansas, that it's 9 months to a year and a half is more the average for getting a probate estate completed. And with a trust, we can move much more quickly. It's private. We can take care of things on the trustee's time and not on the court's time. And all of that, from the privacy to the control to the speed, is what people like. And then also with the trust, we can address, as Logan said earlier, all the what ifs. What if this child is having creditor problems? Do we want to distribute assets directly to that child? What if they've had an illness or an accident and have become disabled and can't work, and now they're receiving governmental benefits, and we don't want them to have this inheritance dropped on them so that they lose all of those benefits? We can plan for all of those things so that the bad things won't happen, and we can provide for almost all of the major what ifs that you can contemplate so that things will go smoothly. And that's why the trust, we say, is the best way to plan, because it gives us an opportunity to cover all those things. Now, some people will think, well, I don't have enough to worry about doing that. I'd rather maybe use beneficiary designations. But those are things that we can talk through, and taking advantage of the opportunity to sit down and have a consultation with us is an incredible benefit, because you can learn what your options are and how they may fit in your situation.
Yeah, one other thing I think we want to maybe touch on the trust. Oftentimes a question Tim and I get deals with tax, and it's estate tax, death tax, inheritance tax. We'll be sitting across the table from a client, and the client will say, well, I don't want my children to have to pay a whole bunch of taxes when they inherit my stuff. And right now we're very fortunate in the way the tax code is set. You have to have a very, very, very large estate before estate tax kicks in. The threshold is over $11 million for the federal estate tax.
Yeah, in 2021 it's $11,700,000. Until you have more than that, nope, you don't pay a penny in estate tax.
But what we tell clients is, and I think we all can understand and appreciate this, that number could change depending on what the folks in Washington may do. If the folks in Congress pass new changes to the tax code and they reduce that, they modify that, that number can always change. The trust does a wonderful, wonderful job of maximizing what a person or what a married couple can pass free from estate tax, regardless of what the folks in Congress may change the number to.
Now, we do know that the Democrats that now have control of the White House and the Senate and the House, they have proposed to reduce our threshold before tax back from this $11,700,000 to $3.5 million. And we don't know for sure that will happen or when, if it does. They've also made a proposal that they'll reduce the ability to make gifts to $1 million during a lifetime, and that any gifts you make that exceed $1 million total would be subject to tax. And again, we don't know whether that will be passed or when, if it is. But we know that there will be changes to estate and gift tax, and it is possible that we're going to have the threshold before tax brought back down to where it may affect some folks. Whereas right now, for an individual's estate at $11,700,000, that affects less than 1/4 of 1% of the population.
Yeah, but clearly it's a moving target. Things may be changing as time goes on. Trust is a great way to provide flexibility and to address those sorts of issues.
Well, the trust can accomplish so much, and we just don't have a time. We could spend an hour and a half just talking about that. But I want to move on and start talking about basic Medicaid eligibility.